Honor, I will just say that since, as you are probably aware, the reason for my withdrawal is that the alleged victim in the case is attempting to implead me in a civil suit between her and Mr. Kearney in the Worcester Superior Court. The situation does not seem to me personally, and I'm not speaking for the office, conducive to enticing a special prosecutor to assume my position. So we'll have to see what develops.
Okay. I'll make an order, Margaret, just as to 240043, the order of the court that the district attorney appoint a special prosecutor within 30 days.
Judge, if I may, we'd just like to be heard on that very point.
Yeah, go ahead.
Attorney Beddoe is going to address that, Judge, just in terms of the potential conflict extending all the way to the DA.
All right, go ahead, Mr. Beddoe.
Judge, the problem with this situation is that the alleged victim, who is dragging Mr. Cosgrove into the case, which has led to his removal, as well as Detective Lieutenant Tully, as part of these series of legal maneuvers, sent a demand letter to Michael Morrissey in his capacity as district attorney, presenting claims against the DA's office arising out of the same incidents which have left Mr. Cosgrove to leave. And it's a classic demand letter. If something's not done within 6 months, she intends to take legal action.
And this is to the Norfolk DA.
This is to Michael Morrissey in his capacity as district attorney, and we believe that the Norfolk DA's office now has an irreconcilable conflict because it would lead to questions about how are they in a position as a future potential litigant to start appointing people. So
why don't you do this? Why don't you write up something and put something in writing to show your opposition? Obviously, I'm not going to. I think it makes sense for the district attorney's office to review whatever it is that you file and then make a decision.
Okay.
On that. Okay.
The last concern with that is at the moment, because Your Honor disqualified Mr. Mello recently in a decision. Mr. Cosgrove has been relieved, and this Mr. Novak has been relieved. This case, the 24 indictment, at this point in time is essentially stateless. There is literally, and I want to overuse the word literally, there is literally no prosecutor on that case for an indictment that is approaching a year and a half, almost 2 years old. There are still outstanding discovery issues, and obviously Mr. Cosgrove is no longer in position to deal with those. Yeah. But we just want to get this remedied as quickly as possible.
Yeah, no, I agree. I agree. So I think I'm pretty comfortable with my ruling that within 30 days someone has to appear from the Commonwealth.
Okay.
Whether that's the Attorney General's office or another prosecutor's office or somebody, but somebody has to come.
Thank you.
I agree with that. All right, now we're going to the other two cases, which are 23-00313 and 25-0088. I think we're on today for discovery motions on that. I know that you have filed a motion to dismiss. I'm sure Mr. Cosgrove hasn't had a chance to respond to that because it was filed within the last week.
We've had some discussion about that, Your Honor. And if the court is agreeable, we have some suggested dates. I believe that we have agreed on a filing date of a non-court date, non-appearance date, but a filing date of October 27th for the Commonwealth to file a response to the motion. And then I believe that both defense counsel and I would be available if it suits the court on either November 12th or November 14th to hear argument on the motion.
Margaret, what is the court schedule like for those days? With Walsh? So it's going to have to go through the regular course. Give me a date later in the month.
I think December.
Yeah, because the Walsh trial is going to start, and I think October 20th, and that will take care of this session for a while.
Is October 20th for?
No, we're talking about, Mr. Cosgrove, having the hearing later in the month of November. The filing date's fine.
Right, so,
Later in November, Your Honor?
Yeah,
They didn't think they were going to be available till December.
yes, well, I mean, the
Oh, is it-
following week is Thanksgiving week.
yeah, okay, then go into the first week of December then.
Any day but the 4th.
Well, that suits me because I can't come on the 4th. So,
The 5th, okay?
Friday the 5th?
Yeah, does that make sense? All right,
Is
okay,
it
so Friday, December 5th.
non-evidentiary motion to dismiss?
Correct.
Yes, I think it's non-evidentiary at that point. There's a prayer in the motion for an evidentiary hearing, but I assume the judge would make a decision as to whether or not to grant that based on the argument on the
Yep.
5th.
It'll be at 2 p.m.
Okay, what else do we have? Do we have any?
There are two other matters, Your Honor, that I'd like to raise with the court. One is a motion for a protective order, certain investigative materials. I have just,
Is this the Brady list?
yes, it relates to the Brady list.
Yeah.
I have just served the actual motion. The attachment was previously provided to the defense, but I believe Mr. Bradel wants to, is okay with taking it up today and wants to be heard briefly on it.
Yeah,
And I'll rely on my written submission.
okay. So what we have before us is a motion for protective order relevant to certain internal investigatory materials, and that has been presented today by Mr. Cosgrove. Mr. Bradel, go right ahead.
Thank you, Your Honor. As the court will certainly remember, we've maintained our objection about public materials,
Right.
about public officials, that, you know, the risk of embarrassment, et cetera, is not a grounds to, you know, hide something from the public. And, you know, a lot of this stuff, the trend has been in the last few years to make police misconduct issues publicly accessible. So, you know, Mr. Kearney shouldn't have less rights than everybody else out there. There's no First Amendment exception for Aidan Kearney that he can't have things that the public can have. So this is one of those issues where, you know, we maintain our objection that there's no reason to impound these items. And the stated reason that, oh, Mr. Kearney might talk about these issues is not a ground, and it fits under the rubric of public officials' misconduct should be out in the public sunshine, and that's that. So it's not a grounds to say, well, Mr. Kearney's going to talk about it. And so it's a simple analysis that the public interest should prevail here, and Mr. Kearney should be included in that and get the benefit of that.
Okay.
So there's no grounds. Thank you.
Gotcha. Okay, what else we got? Anything, Mr. Cosgrove?
I just have one more thing, Your Honor. Judge Rayburn, quite a while back, I want to call the court's attention to this, even though I'm not going to be in the position of litigating it. Judge Rayburn, quite a while back, gave Ms. Gaetani leave to file pro se motions with the court. About 3 days or thereabouts after I became aware of my need to withdraw, there was a release of a link to Ms. Gaetani's cell phone extraction on the internet, which raised a number of issues, having litigated what should happen with this cell phone extraction rather extensively over the course of this case, raised a number of issues that I would otherwise have proceeded with a motion before the court, specifically as to whether the release by someone, and it was not directly released by Mr. Kearney, violated Judge Krupp's order. Ms. Gaetani has filed a pro se motion which sets forth a factual basis for that, and asked for certain remedies. I'm not sure I'm on the same page with her as to what the appropriate remedies would be or whether it also violates Your Honor's order. But I do think it raises very substantial questions as to whether there was a violation of Judge Krupp's order. And I would urge the court to take a look at it and consider whether it's worth a hearing date and how the court should proceed. And that's all I'll say about it.
Okay. Have you seen it, Mr. Bradel?
Judge, have I seen,
What was filed by Ms. Gaetani?
I have.
All right.
First point, Judge, if I may, is that I don't think Commonwealth Counsel is in any position to argue anything on the
I don't think he
case
is.
right now.
I think he's, would agree with that. So what I'm going to suggest is that should probably be put over to a date where there's a new prosecutor here. I agree with you on that. I think Mr. Cosgrove has correctly moved to withdraw in that case based upon the circumstances. And I think that a new prosecutor comes in, we'll take a look at it, and then make a determination.
Sure.
Okay.
And I don't want to take a lot of Your Honor's time on this, but just so Your Honor is aware of our position, is that Ms. Gaetani keeps filing these motions with the court that are creating a serious risk of denying Mr. Kearney of a fair trial, prejudicing him, prejudicing me, prejudicing Mr. Betterow to the court, to the public, and these things keep getting filed by a third-party litigant. There's no privilege in Massachusetts on the part of a third-party litigant to be asking for things like she's asking for in this motion, suppression, a fine, other relief. You know, this is outrageous, and I asked it, we're going to ask in writing when there's a new prosecutor.
Yeah, why don't you do that? Why don't you respond?
Because we just had it with this. It's going to prejudice our rights to a fair trial on behalf of Mr. Kearney. She can't keep taking pot shots with the court. Your Honor has to read this stuff. You know, it should be stricken. It shouldn't even be accepted, is our position.
All right. So I will then see you back, or someone will see you back on whatever date that is that we chose for the hearing.
And one final thing, Your Honor, I'll put on the record that I told Mr. Bradel and Mr. Betterow that with respect to the most recent indictment against Mr. Kearney that involves him standing outside the pizza shop,
25
making faces, that I would provide him with the discovery by the next court date.
Okay.
And that's agreed to, Judge. That's perfectly fine. I did file 2 arraignment motions that I would just ask the Commonwealth to look at in terms of what we're looking for in terms of the response.
Okay. Sounds good. Thank you all.
Thank you, Your Honor.
Your matter is continued to December 5th at 2 p.m.
All right. Have a nice day.
Thank you.
All right, did everyone catch what just happened there? Let me get rid of the Zoom.
What are they? So in the 25 page, it's a motion for exculpatory discovery. That's the grant.
Folks, did you hear what just happened there? We're going to review the motion Judge Doolin was talking about. 2 big things just happened there, all right? That was a very quick hearing. It happened very quickly. My name is Grant Smith-Ellis. If you want the recap, we can do it. I got as much of the hearing as I could. Okay, I'll tell you exactly what just happened. All right, that was explosive. Thank you so much for joining me. What just happened was the charges against Aidan Kearney are not getting dropped, okay? Judge Doolin ordered. This is not a choice. He took the decision out of the hands of the Norfolk County DA. He ordered the Norfolk County District Attorney's Office to appoint a new prosecutor, including potentially the Attorney General of Massachusetts if needed, within 30 days, ladies and gentlemen. Even after Kearney tried to renew some objections to that attempt to Judge's order, Judge said, nope. Judge Doolin said, I feel comfortable with my order, and I'm ready to move forward with it. So there is forget about the charges being dismissed, folks. Judge Doolin just took the decision out of the hand of the Norfolk County District Attorney's Office. He took it out of their hands and he said, you will appoint a new special prosecutor. Not you will go on a search. You will appoint one, and if you can't find one, you'll send the Attorney General to the next hearing who will represent you. Oh, wow. Yeah, bring in Leah Foley, ladies and gentlemen. So that was a rapid hearing. Let's talk about it quickly. Judge Doolin, that was the very first thing he did. He said, no discussion, order of the court. He ruled from the bench. listen, Judge Doolin suspects something is wrong here. If he's ruling from the bench that the Norfolk DA has 30 days to replace Robert Cosgrove on the Lindsey Gaetani cases, okay, the 2 felonies that were charged originally in December of 2023 and then bound over sometime in I think March 26th of 2024, folks, he ordered it. That you must understand the weight of what Judge Doolin just ordered. All right, that is not something you see every day. Normally, this is a very deliberative process. No, that is an order of the court from the bench, basically sua sponte. There was no motion from anyone to appoint a new prosecutor. It was just a motion to withdraw. There could have been any number of things. Judge Doolin didn't even let the conversation start. Judge Doolin stood up there and said that motion, the motion to withdraw can be granted, but you have 30 days. He didn't order Robert Cosgrove to do anything. He ordered the Norfolk County District Attorney's Office to appoint a prosecutor, or in lieu of that, send the Attorney General onto the case to prosecute it. That's an order of the court. No negotiation. It was finalized. Now, Aidan Kearney has a right to file pleadings about it, but Judge Doolin already said, no, he reviewed it kind of after a little bit of argumentation. Was like, no, that's my order. That's my order. And that's how it came down. New prosecutor on Lindsey Gaetani's cases within the next 30 days. No ifs, ands, or buts. Then we went immediately, I was just blown away by this. We went immediately to 2 other issues. The only things that were really discussed was when can we have a date for the motion to dismiss that Kearney just filed, and that's going to have to be sometime in November after there's a new prosecutor on the on some of these cases. And then the other things that came up was Robert Cosgrove wants a protective order to prevent Aidan Kearney from sharing the Norfolk County Brady list, which is the list of cops in the county who have credibility determinations against them and that makes them unreliable witnesses. It's called a Brady list, or maybe a Giglio list, something like that. And then the third thing that came up was even more explosive. Lindsey Gaetani's motion for sanctions came up, and Robert Cosgrove, on his own accord, said, well, you know, I was going to file something like this, but because I'm getting off the case anyway, Judge, there's some really good points in that motion, and you should consider it. And this is about the release of Lindsey's unredacted phone extraction in violation of Judge Peter B. Krupp's December 27, 2024 protective order that was just ruled on the validity of it by Judge Doolin earlier in September of 2025. It was violated almost within a week or two of Judge Doolin upholding Judge Krupp's protective order on that unredacted extraction, which, by the way, was released by Brian Tully on April 24th or something of 2024. Very interesting. Very interesting. So we're going to take a look at that motion for sanctions, motion for contempt against Kearney, because Cosgrove stood up there and endorsed it. He sung its praises. And we're going to listen to the motion be read out, and then we'll watch the clip of Cosgrove talking about it, because how can you understand what the hell Cosgrove's talking about if you don't see the motion? So there it is. And then I also have it, I have the ability to read it out, because I want to type up what Cosgrove just said, because there were so many rapid fire developments. So while I'm doing that, let's listen to this motion be read out, and let's see if I can make it happen. Come on, bot. Do us proud. Have faith. Have faith in the bot, folks. We trust the bot. We love the bot. The bot will do us proud. You can do it. Hold on. Go ahead. Any second now.
Commonwealth of Massachusetts. Norfolk SS. Superior Court. Criminal No. 23-313. Criminal No. 24-43. Commonwealth OIE. A. VSAE and copyright. Aidan Timothy Kearney's I equals. OA G. Lindsey Gaetani's motion for finding of contempt. Imposition of sanctions against defendant Aidan Timothy Kearney for willful and knowing violation of protective order. Now comes Lindsey Gaetani, victim in docket No. 23-13 and witness and interested party. In docket No. 24-43 collectively, the cases proceed pursuant to the court's order. Dated September 26, 2024 Hom. Katie Rayburn J., granting her leave to file pleadings and respectfully moves this honorable court, pursuant to Mass. R. Crim. P. 44, GLC 211, Section 3, the court's inherent contempt power and principles of equity and justice for a finding of criminal contempt against defendant Aidan Timothy Kearney, defendant or Kearney, for his willful, knowing, and repeated violations of the protective order dated December 27, 2024, the protective order issued by the Honorable Peter B. Krupp J. M.S. Gaetani further requests an expedited evidentiary hearing, imposition of sanctions, and such other relief as the court deems necessary to vindicate its authority, protect Ms. Gaetani's rights under DL. C. 258B Crime Victim Bill of Rights, and preserve the fair administration of justice. This motion is supported by the accompanying affidavit of Lindsey Gaetani, Exhibit J, the exhibits referenced herein, and the following memorandum of law. In support of this motion, Ms. Gaetani states, I. Introduction and procedural posture. The protective order was issued by the Honorable Judge Krupp on December 27, 2024, to prevent irreparable harm to Ms. Gaetani by prohibiting the unauthorized dissemination of her unredacted cell phone extraction, a forensic image containing over 15 years of sensitive, privileged, and irrelevant data, including attorney-client communications, medical records, personal photographs, and other protected material. The order explicitly bars defendant and his counsel from disseminating any extraction material, whether directly or by means of any third party, for strictly limited litigation purposes among the defense team in the instant matters only. Exhibit A, Protective Order 3. It mandates destruction of all copies, certification of compliance under penalty of perjury, and safeguards for court use. FJ 2, 5-10. On September 5, 2025, the Honorable Judge Michael P. Doolin upheld the order, rejecting defendant's challenges and affirming its necessity to protect privacy and prevent prejudicial publicity. Exhibit B. Defendant has brazenly defied this mandate through a pattern of violations, culminating in the September 11, 2025, Obley's release of the entire unredacted extraction on X, formerly Twitter, by Jason Broyles at H1 Your Case, a known proxy to whom defendant has admitted leaking protected materials. The posts http URL n http URL your case status 1,366,358,273,046,524,211 provide direct links to the extraction, flouting the order's ongoing prohibition. Exhibit CD. Even if Broyles obtained the files before December 27, 2024, their dissemination now, while the order remains in full force, constitutes a willful violation attributable to defendant, given his established agency relationship with Broyles. This act, following prior violations, exhibits FG, inflicts profound harm on Ms. Gaetani, taints the jury pool, and undermines judicial authority. Compounding these violations, on September 14, 2025, mere days after Broyles released defendant broadcast on YouTube episode 807, Wilbur Show Overview. Cosgrove won't give phones back to Ver. Update http URL we.com/watch equals KD2DC where he admitted to previously distributing the extraction to multiple individuals, discussed its contents in the context of the protective order, and effectively directed viewers to access the now widely disseminated files by noting it all over the fucking internet and implying they can find it independently. Exhibit H. These statements not only reinforce defendant's role in the initial leaks but also encourage further dissemination, constituting additional willful contempt. Massachusetts courts possess inherent power to punish such disobedience through criminal contempt. J. Henry McCabe, 410 Mass. 1647, 1649-50, 1991. Ms. Gaetani respectfully urges Swift action by the court to deter further misconduct, uphold its prior orders, and remedy ongoing prejudice. Ill. Statement of facts. A. Background, the inadvertent disclosure and protective measures. 1. On or around April 24, 2024, Massachusetts State Police Lieutenant Brian Tully negligently and inadvertently disclosed the unredacted extraction to defense counsel Timothy Brattle, who shared it with defendant despite the Commonwealth's immediate clawback request under Mass. R. Prim. P. 14 Exhibit A, Section 1. Exhibit E, Gaetani motion. Who? Exhibit J. 2. MS. Gaetani surrendered her cell phone in December 2023 based on then Special Prosecutor Ken Mello's oral assurance of screening by a reverse taint team to protect irrelevant/privileged data. Despite repeated requests, she has not received the signed consent form Exhibit E, Exhibit J. 3. Following defendant's initial unauthorized disseminations, this court issued the protective order on December 27, 2024, after negotiations and MS. Gaetani's impounded letters file refs #59-60-77 Exhibit A, Exhibit E, 44I Roman 3, Exhibit J. 4. On September 5, 2025, Judge Doolin upheld the order, rejecting defendant's first amendment and protective order challenges, emphasizing that discovery materials are not public judicial records and that privacy interests justify restrictions. Exhibit B, citing Seattle Times Co. v. Reinhart, 467 U.S. 20-33 1984, United States v. Kravitz 706 F.3d. 47-54 ISSER, 2013. In Judge Doolin's order, defendant's repeated history of violating the protective order was included as findings of fact by this court. B. Defendant's pattern of violations. 5. On July 8, 2025, in YouTube episode 790 Turtle Boys Day in Court, Karen Reed Cops rehomed, defendant publicly discussed extraction contents, making inflammatory, misleading claims and admitting to putting a lot of it out there. Exhibit F transcript. At 1:56:20, Exhibit J. 6. Defendant admitted leaking MS. Gaetani's unredacted rape report, provided to Kearney in
Trigger
the
warning.
context of discovery for the instant matters to broils for dissemination. In an August 10, 2024 YouTube episode EP 686 Karen Reed case, motion to dismiss. Natalie the German shows up at court. Kearney stated, I provided the report to Bruce for posting Exhibit G, Exhibit J. C. The September 11, 2025 violation. 7. On September 11, 2025, Broyles released the full unredacted extraction on X. Since Post 1 ID 1,966,338,10,472,124,5x tilde evening EDT announced the full extraction of LGMS Gaetani with Proton Drive links. HTTP URL Exhibit C Screenshot/full text E-Post 2 ID 1,966,358,273,273 MIF-211 tilde 12:28 a.m. EDT September 12 quoted A defiant statement rejecting restrictions and provided Google Drive links. HTTP URL NWK9YKZTSUB2UI QCKNT5H tilde JJOMGE CNS equals sharing Exhibit D/screenshot/thread. 8. Broyles reference to his source and prior collaboration with defendant confirm agency. Exhibit D replies, I published exactly what my source represented was what the Commonwealth provided. Exhibit J. 9. The posts, viewed thousands of times, cause MS Gaetani severe emotional distress, harassment, and safety risks. Exhibit D. ongoing violation regardless of when files were obtained. 10. Even if Broyles obtained the extraction before the protective order's issuance on December 27, 2024, for example, between April 24, 2024, and December 27, 2024, the dissemination on September 11, 2025, violates the order, which remains in full force. The order prohibits defendant from disseminating extraction material directly or by means of any third party and requires destruction of all copies by January 10, 2025. Exhibit A, J2-3, 5. Defendant's failure to ensure destruction and his coordination with Broyles to publish now post-order constitutes a continuing violation. See United States v. Keller, 58 F.3D 80-25, 834 2D Sir. 1995 dissemination via agents after protective order is contemptuous. The order's mandate applies prospectively, capturing any retained copies or orchestrated releases, as evidenced by defendant's established pattern of using Broyles as a proxy. Exhibit G. Exhibit J. E. The September 14, 2025 violation. 11. On September 14, 2025, defendant further violated the protective order during his YouTube broadcast episode 807, Wilbur Show Overview. Cosgrove won't give phones back to ver update, http URL. In the episode, defendant admitted to distributing the unredacted extraction to a whole bunch of people shortly after receiving it in April 2024, stating, "I already distributed it to a whole bunch of people. I don't even remember what we gave." I'm like, bro, you gotta see this shit. This shit's crazy. Like, it was just given to us. How could I not share that? Defendant acknowledged the protective order's existence and his obligation to destroy copies, but noted that the extraction is now all over the fucking internet due to secondary sharing by recipients, implying viewers could access it independently without his direct involvement. Exhibit H. Transcript excerpt 1. 12. In the live chat section of defendant's September 14, 2025 broadcast, Erica Walsh, one of the users who serves as a moderator, person with power to remove comments and users from the live chat, posted a direct link http://avoalinsisphone.com to the full contents of Ms. Gaetani's phone. Exhibit I, screenshot of Kearney's YouTube live chat. September 14, 2025. Defendant took no steps to remove the link and, thus, facilitated distribution of the extraction by a third party in violation of this court's order. 13. In a second segment, defendant normed to reference or discuss content potentially derived from the extraction, such as comments on individuals coming together for her and tax implications, further promoting scrutiny of Ms. Gaetani's private information. Exhibit H. Transcript excerpt 2. Exhibit J. These statements not only confess prior violations but also encourage ongoing dissemination by directing viewers to the widely available files in defiance of the order's ban on indirect facilitation through third parties or public discussion. I. Memorandum of Law. A. Criminal contempt standard. Criminal contempt requires proof beyond a reasonable doubt of 1. A clear, unequivocal order, 2. Defendant's knowledge, and 3. Willful disobedience obstructing justice. In re McCabe 410 Mass. At 650, Martinez v. Lynn Hughes. Auth. 94 Mass. App. CT. Seven 2019. The protective order's prohibition on dissemination directly or by means of any third party is unambiguous. Exhibit A, 4.3. Defendant had noticed certified compliance for 6 and unsuccessfully challenged at Exhibit B. His orchestration of the September 11 release through Broyles, whether files were obtained pre or post-order, demonstrates willfulness, as he failed to destroy copies and directed their current publication. Cutler, 58 F3D at 834, United States v. Lind, 198 F. Sup. 2D 739, 743 ed. Va. 2002. Defendant's September 14 admissions. Facilitation and encouragements of sharing the protected material further establish ongoing contempt. Mass. R. Crim. P. 44 authorizes prosecution by complaint or indictment for non-summary contempt. GLC 2/1, Section 3. In re-opinion of the Justices, 475 Mass. 1201, 1205. 2016. B. Ongoing violation despite timing of acquisition. The protective order imposes a continuing obligation to refrain from dissemination and ensure destruction of extraction copies Exhibit A 2-3-5, even if Broyles received the files before December 27, 2024. Their release on September 11, 2025 violates the order's current prohibition. Courts have held that dissemination of protected materials after an order's issuance, regardless of when acquired, constitutes contempt if done willfully through agents. C.J. Henry. Grand Jury Subpoena 826 F2D 1.166 1.171 2D Sir. 1987 Contempt for post-order disclosure of materials obtained earlier. Defendant's agency relationship with Broyles admitted in prior leaks. Exhibit G imputes the violation to him. His September 14 broadcast extends this by admitting pre-order distribution and promoting access to the now disseminated files Exhibit H, Exhibit 1. C. Victim and third-party protections. Mass. R. Prim. P. 14/6 and GLC 258B, Section 3 Protect Miss Gaetani's privacy and dignity. Commonwealth v. Fuller, 423 Mass. 216, 226 1996. The extractions release risks jury prejudice and irreparable reputational harm. Seattle Times, 467 U.S. at 35, Baxter Intel, Inc. v. Abbott Labs, 297 F.3D FNVA 44, FNVA 45 7th Sir. 2002. D. Necessity of sanctions. Sanctions are essential to deter defendants' pattern of misconduct and remedy harm. J. Henry. Keenan, 310 Mass. 166, 178 1941. United States v. Smith, 985 F. Sup. 2D 506, 527 STNY. 2013. Roman 4. Requested relief. Wherefore, M.S. Gaetani respectfully requests that this honorable court 1. Schedule an expedited evidentiary hearing within 7 days. 2. Find defendant Aidan Timothy Kearney in criminal contempt. 3. Impose sanctions including A. Incarceration for up to 90 days or until the violation is purged, for example removal of posts/files/websites. B. A fine of at least $20,000. C. Exclusion of all extraction-derived evidence at trial. D. An adverse inference jury instruction against the defendant regarding that evidence. E. An award of M.S. Gaetani's costs, fees, and damages for emotional distress. 4. Refer the matter to the Norfolk County District Attorney or Attorney General for prosecution under Mass. R. Crim. P. 44. 5. Issue an interim order directing defendant to cease violations, including any further public discussions or encouragements to access the extraction on YouTube or other platforms and cooperate in removing the ex posts, linked files, websites, and related broadcasts. 6. Extend the protective order to any and all future or prior discovery provided to the defendant in the instant matter involving M.S. Gaetani, and 7. Grant such further relief as the court deems justice requires.
All right, folks. So if you're wondering why were we listening to that, well, we should definitely take a listen to what Robert Cosgrove said in court today, because it bears directly on what was just read. Robert Cosgrove didn't enumerate the motion per se, but Robert Cosgrove had some things to say, and I have the clip for you. Now, Aidan Kearney's attorney, Tim Bradel, was... to say he was off-kilter today, it was, first of all, not a quick hearing, so he didn't really get to bloviate, in my opinion. And then second of all, this was what Robert Cosgrove said about the motion we just read. So let me see if I can get this over on the screen for you here. No promises. All right, I did it. All right, look at me being an effective little towel. So let me get you this video in a way that's a little bit easier to see, and then we'll watch it from the beginning. Don't worry, I have the audio. And so what we're going to listen to right here is Robert Cosgrove's going to, even though he is being removed, he's removing himself from the case. And let's be clear, if you missed earlier in the recap, after Robert Cosgrove tried to remove himself from the case, it was allowed, but Judge Doolin, who's on the bench, did not give any grace or discussion. He immediately issued an order from the bench that there be a new special prosecutor, including, if necessary, from the Attorney General's office in Massachusetts, appointed within 30 days, folks, on the Lindsey Gaetani case. Now, of course, the issue here is the repeated release of protected documents by people either in the state police unit involved with the Norfolk County District Attorney's Office or with the prosecutors involved with the Norfolk County District Attorney's Office. And I think I heard Judge Doolin said it. He was like, listen, if this just has to be the Attorney General that prosecutes these cases, so be it. But that's absolutely bombshell news, because there was no negotiation and it was an order from the bench, which is binding. Aidan Kearney's going to be given permission to file pleadings about it, but that was what Judge Doolin said. But a new prosecutor, including, if necessary, the Attorney General of Massachusetts, her office, Andrea Campbell, is going to be put onto this case. It was an order of the court. You have 30 days from today. Norfolk DA, that was the order. You have 30 days to find a special prosecutor. If you really can't find one, it's going to be the Attorney General. And then Judge Doolin said, I don't care what happens, there's going to be someone in this courtroom, he ordered it, for our next hearing to represent the prosecution on these cases, including, and he said it again, if it needs to be the Attorney General, it will be the Attorney General. So, I don't think that's how Aidan Kearney expected to walk out of court today. You go in thinking Cosgrove's going to withdraw, and then Judge Doolin's like, this reflects a level of intimacy and familiarity, in my opinion, with the case on behalf of Judge Doolin that's just incredible. Okay, folks? Judge Doolin is my opinion, he's speaking without speaking. Now, mind you, Judge Doolin ruled in my favor today. I submitted a motion to broadcast the hearing via Zoom, and he approved it. I was a happy little towel. So, but Judge Doolin, and this is my analysis, okay, this is part of what we do here on this stream. For Judge Doolin to have reacted that way, and we can watch the clip of it, but for Judge Doolin to have reacted the way that he did, and immediately issued a sua sponte order. He doesn't issue orders from the bench. I don't know if you watch these trials. I have been following this case and the Reed case, whatever, for a long time. Judge Doolin, when he appears, is a very contemplative, deliberative jurist. Very, very, very focused on rulings. When he issues an order, he took 4 months on a motion to dismiss once. He takes like 3 months on more like procedural motions. He's so... And I'm not saying like simple pro forma motions like, you know, motion to impound or whatever. He'll do that right away. But when he writes a ruling, he really thinks about it. Like, he takes time, he waits, nobody's going to rush him, he's going to write a good ruling. Okay, I've never seen Judge Doolin do that. He preempted, so it's like a sua sponte, which means like on the judge's own accord kind of thing, which is very interesting. What happened was, and we'll watch the parlay between the different parties as it played out. Cosgrove moves to withdraw. Judge Doolin just jumps in. He immediately issues an order sua sponte from the bench. No one asked him to do this, and says that I'm ordering the Norfolk County District Attorney's Office to find a new special prosecutor, or if need be, appoint the Attorney General to prosecute the cases involving Lindsey Gaetani now that Robert Cosgrove is withdrawn. What? What? Out of nowhere. And then Kearney raises some objections through his lawyer, Tim Bradle, orally. And Judge Doolin says, you know, he kind of does his Judge Doolin thing where he's kind of like thinking, he's like, no, you know what? I'm comfortable with that order. You can file some pleadings, but I'm comfortable with my order. 30 days. What? You could have asked me to draw a chart of all the possibilities of what could have happened at today's hearing. There is no chance I would have predicted that it would have been an order from Judge Doolin to the Norfolk that you cannot, it's not a discussion, an order to appoint a new prosecutor, and then that would have blown my mind. And then for it to just happen from the bench, Judge Doolin does not do that kind of thing. And my analysis here is he saw some tomfoolery. He must have thought that there was tomfoolery with the motion to withdraw, and he must have seen that this might have been an attempt to just drop those two cases. And so I just want you all to understand, in my opinion, my lay opinion, I'm not a lawyer, this is not legal advice, the implications of Judge Doolin doing that, we'll watch the moment in a second here, so quickly, okay? Sua sponte from the bench. He wasn't considering what he was being told. He knew what he was going to do before he sat down at that bench. Now, I want folks to understand, I have seen cases where the government has tried to drop something. This was in different districts, federal mostly, where the government has filed a motion to drop a charge, and the judge sua sponte prosecuted the charge. The judge appointed a prosecutor and made that person prosecute the case. We didn't have that here. We weren't at the point where Cosgrove was motioning to dismiss the charges involving Lindsey. We were at the point where Cosgrove was just withdrawing from the case. But Judge Doolin's reaction, listen, unheard of. I cannot believe that happened. Maybe normal course after arguments or something over the next month, you might get a written order like that. To issue sua sponte immediately upon Cosgrove withdrawing an order binding the Norfolk DA to either appoint a special prosecutor or appoint the Attorney General, I mean, it's out of their hands. That's Judge Doolin saying, wherever the hell this was going, wherever you all think you were taking this, oh no, I'm derailing that train, and we're going right over to this other track here and enjoy the ride on Judge Doolin's Express. Okay? Incredible. Incredible. Wonderful moments. We have a poll going right now in Towel Chat about whether people are just astounded and proud and just in awe of Lindsey Gaetani. Now, frankly, I'm pretty much in awe. I don't know how... I'm just blown away. This is very, very impressive. So, to all you voting in the towel poll, thank you very much for doing so. And I will tell you right now, I'm impressed. Okay? I'm impressed. I'm just all around impressed. Oh, no, I froze the towel comments. All right, I'm trying to get them back. Hold on. Oh, I see. I was like, where are the towel comments? I have them. I have found the towel comments. We have a poll. Right now, the vote is Lindsey Gaetani, a fighter and a hero for protecting yourself and in light of Judge Doolin's order. Yet, 79% of you have voted yes, we love her. 21% of you have voted no, I hate puppies and balloons. What the hell is wrong with you? How can you dislike puppies or balloons? Now, I understand maybe there's an argument for, you don't like balloons popping, but just the notion of a balloon, come on, what kind of savage? You basically have to be a communist to hate balloons and puppies, all right? You know what I'm saying? Now, I will say this is absolutely incredible. No, and LS, it's not an option. I just want folks to understand, when people think like, oh, it's going to be really hard to find someone, this is not a negotiation. You have a binding judicial order. Binding. I don't care if you go in there with Andrea Campbell herself next time, you are showing up, Norfolk DA, with an attorney to prosecute this case. Violate that order at your peril. That's what that means. And I was just in the middle of analyzing how when it comes sua sponte, orally from the bench, before anyone can say anything, it's a message from that judge, don't try any tomfoolery, find a prosecutor or bring the Attorney General, don't mess with me. This was Judge appointing a prosecutor. You want to see someone stand up for Lindsey Gaetani, it's Judge Doolin. Right there. Never seen anything like it in my life. Very incredibly unique set of circumstances, but that is how you do it. No negotiation. And there will be people who will, and of course the defendant, in my opinion, will want to go around saying, oh, they'll never find anyone. Okay, they're gonna go find someone. They're literally gonna bring them into court, and they're going to present them to avoid being in violation of Judge Doolin's order. Now, some people may think, oh, it's a court order. Look at all these people who just flout them. Okay, you violate that order. Go ahead, Norfolk District Attorney's Office. Violate that order. That's a brilliant life decision. It's not. That's why I'm saying Judge Doolin he's a very calm, cool, collected jurist. He's not going to be like screaming at them, but there is a way to issue an order that has such weight and such force that the message is, I'm incredulous. No, and you are going to do what I say. That's what exactly happened. Now, we will watch the moments. Let me get the live stream up here so we can watch it together. I got to rewind my own live stream. But let me just tell you, that was like, yes, it was not delivered with this booming, like ferocious tone. Okay, you're not going to get that from Judge Doolin. It was the content of the order. You got to understand, I know some of you do, but it was the content, it was the way he told, it was the substance of it. You will do this in 30 days, and then to include that little nugget in there. Oh, and by the way, watch it together. I'm going to rewind my own stream. By the way, you're also going to, if you need to, appoint the Attorney General. I've never seen anything like it in my life. Oh, God. All right, it took me a little bit of time to get the audio connected at the beginning, but let me make sure. Hold on one second.
So,
all right, one sec.
300
recently in the Cosgrove to leave.
Yeah, go ahead.
All right, I got it. All right, so we're going to watch this together. This is what I was just explaining to you. This is the moment that it happened, okay? We're going to watch it together. Let me center it a little bit better for you, all right? So this was the moment. I am not exaggerating. I want you to watch what Judge Doolin said. I want you to keep in mind what I just talked about to begin our recap, and then I want you to compare it, and you tell me if the series of events lined up with how I described it. And it was quick. This is not a long recap. There wasn't much to talk about. Judge Doolin was furious. I've never seen anything like it. Let's do it.
Attorney Beddoe is going to address that, Judge, just in terms of the potential conflict extending all the way to the DA.
All right, go ahead, Mr. Beddoe.
Judge, the problem with this situation is that the alleged victim, who is dragging Mr. Cosgrove into the case, which has led to his removal, as well as Detective Lieutenant Tully, as part of these series of legal maneuvers, sent a demand letter to Michael Morrissey in his capacity as district attorney, presenting claims against the DA's office arising out of the same incidents which have left Mr. Cosgrove to leave. And it's a classic demand letter. If something's not done within 6 months, she intends to take legal action.
And this is to the Norfolk DA.
This is to Michael Morrissey in his capacity as district attorney, and we believe that the Norfolk DA's office now has an irreconcilable conflict because it would lead to questions about how are they in a position as a future potential litigant to start appointing people. So
why don't you do this? Why don't you write up something, put something in writing to show your opposition? Obviously, I'm not going to. I think it makes sense for the district attorney's office to review whatever it is that you file and then make a decision on that. Okay.
The last concern with that is at the moment, because Your Honor disqualified Mr. Mello recently in the decision. Mr. Cosgrove has been relieved, and this Mr. Novak has been relieved. This case, the 24 indictment, at this point in time is essentially stateless. There is literally, and I want to overuse the word literally, there is literally no prosecutor on that case for an indictment that is approaching a year and a half, almost 2 years old. There are still outstanding discovery issues, and obviously Mr. Cosgrove is no longer in position to deal with those.
Yeah.
But we just want to get this remedied as quickly as possible.
Yeah, no, I agree. So I think I'm pretty comfortable with my ruling that within 30 days, someone has to appear from the Commonwealth.
Okay.
Whether that's the Attorney General's office or another prosecutor's office or somebody, but somebody has to come in.
Thank you.
I agree with that. All right.
Love it. You love to see it, little towels. Oh, you love it. And exactly, Tanya said, Judge Doolin put belt to bottom while being cool as a cucumber. Oh, yeah. No negotiation. You Commonwealth will appoint a special prosecutor, or you will bring the Attorney General. That is a very serious order. It's not a joke. It's delivered in a subtle way, but the implications are, don't mess around. You don't even think about it. I expect to see someone here next time we're going forward. I'm pretty comfortable with my ruling that I made all of 5 minutes ago. Thanks, Mr. Betterow. I'm still comfortable with it. Yeah, I don't know if I think Judge was thinking about that, obviously, before oral argumentation, and he knew he was going to rule that way. He wanted to deliver a message. Now, he's not bombastic. Judge Doolin is a very composed, sort of erudite, learned jurist. He's stoic, I would say. He's not bombastic. And so in that regard, yeah, I think that the way he delivered that, cool as a cucumber, but the substance of it is so crushing. It's non-negotiable. It's an order. You will do this. It completely undercuts the ability of the Norfolk DA to leverage any of this. The DA can't drop it. You have an order to appoint someone and send them here. You think Judge Doolin's going to approve a motion to by the Commonwealth to withdraw the charges? It's rare, but there's judicial discretion. I think the federal rule is like Rule 5 or something. There's judicial discretion to just say, no, you're not dropping them. I will appoint a prosecutor and you will take this through. I don't know if people understand how powerful a judge is. This is absolutely one of the kind of things that a judge can do. In fact, he just did it. And if the Norfolk DA did some tomfoolery, as I'm suggesting, what you would see from Judge Doolin is not bellowing. You would see an order, like if they tried to dismiss it or whatever, I think you would see an order saying, no, I think I'll appoint a prosecutor, which is what he basically just did. The cases are going forward. It's going to trial. It might get prosecuted by the Attorney General. Now, the Attorney General may have declined to prosecute some cases against Aidan in the past. I saw some documents on social media about that. But this isn't really a choice. The government of Massachusetts has to comply with that order. Whether you send a new special prosecutor, whether you send the Attorney General or an assistant Attorney General, whether you appoint a special Attorney General, which is like a special prosecutor with even more power, it makes it I've never seen anything like that. Now that I think about it, it was kind of like a punishment for Aidan. It really ramps up the severity of the defendant's situation, in my opinion, because it's like this, it's a forewarning from the judge that, he's very upset. It was basically a sanction. By other means, I mean, mandating the appointment of a prosecutor, it strips the Norfolk DA of the foundational prosecutorial discretion that defines the, adversarial criminal justice process. But in this situation, I'm telling you, that I hope folks understand how rare this is. It's the judge saying, not only am I stripping you of that discretion, I'm ordering you to appoint someone, and by saying the word Attorney General, it makes it so much worse for Aidan Kearney, because the judge is basically saying, whatever you do to put someone on this case, expect to be dedicating resources and taking the case to trial. The Attorney General doesn't really criminally prosecute a lot of stuff. They can, I'm pretty sure, but they don't. This might be Aidan may just have walked himself into a very bad situation. You put the Attorney General prosecuting a state criminal case. Oh my God. The resources of that office, and they don't have to prosecute it directly. They can appoint a special assistant Attorney General. The budget's 50 times, probably 100 times the Norfolk County DA's budget. yeah, I don't need, listen, as you're, regardless of what Aidan's lawyers want to comment on about this, in my opinion, you got to just look at what the judge said. I mean, there's no way around it. We don't know how the next 30 days are going to be playing out, but we could legitimately see an attorney general, a special assistant attorney general appointed with the budget of the attorney general's office to prosecute just Lindsey's cases. And that's why I'm saying, like, it almost felt like Judge Doolin being like, you are not doing this to this poor woman, like to Lindsey. And I mean, I need a few minutes to kind of like compose myself. I'm going to go for a walk after we get out of here. Like, God bless him, man. Like, what a really, I'm going to cry if I keep thinking about this. Like, Noel, we can watch it on social media. I don't really want to give him a platform. But I just want you to understand that it's very nuanced. Like, it's easy to propagandize. I don't think a lot of people, even in the news media, watching that hearing, are going to have picked up on the gravity of what Judge Doolin just did and like the heroism of it. What he just did was such a noble, selfless sort of. Man's a hero. He didn't have to do that. He did not have to do that. He could have just. The normal course would have just been like, okay, figure it out. Like, you're the prosecutor. Decide what you're going to do. No. He suspected something's wrong, and he ordered them to appoint someone. And I really, whatever Aidan says outside court or whatever his lawyers say, I don't think they understand. Maybe they do. Bettero's from New York, though. I don't know if they appreciate what it would mean if the full weight of the Attorney General's office was the only criminal case they were prosecuting was Lindsey Gaetani's case involving Aidan Kearney. And that's why I'm saying, like, I think Judge Doolin understood what he was doing here. I think he was giving her some help. Not, like, in a way that favored either side. I think he was like, but all of you have screwed this woman. Like, I'm not letting you do this to her. That's what the undercurrent of it was. And I'm just like, God bless that man. You know what I'm saying? God bless him. Somebody give him the Nobel Peace Prize. He can share it with President Trump. I'm just, no, yeah, and so I need some time to process this. Incredible. Just incredible. And then to add on to that, yeah, the hearing for the motion to dismiss had to get scheduled down the road, probably late November, I think. And then there's also, this is the part we have to listen to next, Robert Cosgrove. Listen to what he said next. I could not believe he said this. I've heard some stuff in some hearings. That motion for contempt we just read, I mean, God bless Lindsey. Because listen to what he just said, okay? Listen to what Cosgrove says at the end of the hearing. Let me make sure I can get that's the full thing. All right, listen to this.
I want to call the court's attention to this, even though I'm not going to be in the position of litigating it. Judge Rayburn, quite a while back, gave Ms. Gaetani leave to file pro se motions with the court. About 3 days or thereabouts after I became aware of my need to withdraw, there was a release of a link to Ms. Gaetani's cell phone extraction on the internet, which raised a number of issues, having litigated what should happen with this cell phone extraction rather extensively over the course of this case, raised a number of issues that I would otherwise have proceeded with a motion before the court, specifically as to whether the release by someone, and it was not directly released by Mr. Kearney, violated Judge Krupp's order. Ms. Gaetani has filed a pro se motion which sets forth a factual basis for that and asks for certain remedies. I'm not sure I'm on the same page with her as to what the appropriate remedies would be, or whether it also violates Your Honor's order. But I do think it raises very substantial questions as to whether there was a violation of Judge Krupp's order. And I would urge the court to take a look at it and consider whether it's worth a hearing date and how the court should proceed. And that's all I'll say about it.
Okay. Have you seen it, Mr. Bradle?
Judge, have I seen,
What was filed by Ms. Gaetani?
I have.
All right.
First point, Judge, if I may, is that I don't think Commonwealth Counsel.
So then Bradle goes on to just kind of say, how dare Judge Rayburn, but basically Bradle was like, I'm summarizing, how dare Judge Rayburn let this witness victim file pleadings? How dare Judge Rayburn? That was the content of his argument. Now, I don't think Judge Doolin was very pleased with that argument. And so what's crazy is there's a little bit more at the end of the discussion, and Judge Doolin goes on to say that after the new prosecutor is appointed, they're going to have a contempt hearing potentially. Bradle wants to move to strike the pleading, but I don't think that's going to work. They want to move to have a contempt hearing, okay? The only thing that came out of today was a future date for the motion to dismiss and then a potential contempt hearing. A contempt hearing. I don't know if folks understand what a contempt hearing is. Like, the judge you're in contempt of the court's order. So I'm not a lawyer, this is not legal advice. But the judge, that's why I think, but this might have played into what Judge was thinking about today. I don't know. But that motion for contempt that we read, and then the way Judge reacted to Cosgrove withdrawing, and then Judge issuing his sua sponte order from the bench for a new prosecutor to be appointed within 30 days from either the Norfolk DA as a special prosecutor or the Attorney General or a special assistant Attorney General, however it plays out. You have to imagine Judge Doolin has that in his mind, because it's so interesting that he then goes on to say, to talk about this contempt motion and potentially scheduling an evidentiary hearing. This is different than an evidentiary hearing involving any of the witnesses or any of Kearney's arguments. This is a question of whether Kearney, that would be a hearing it could be about multiple things, but that part of the hearing would be just about whether there was a violation of Judge Krupp's protective order. Listen, that's basically what's called a show cause hearing, okay? And you don't, the normal order of course, in my opinion, I'm a lay towel, I'm not a lawyer, this is not legal advice. The normal order of course would be Judge Doolin sees a violation brought to his attention. Judge Doolin issues a show cause order as to why Kearney should not be held in contempt. Here we have a motion from Lindsey Gaetani under an order from Judge Rayburn allowing Lindsey Gaetani to file pleadings about Aidan Kearney violating Judge Krupp's protective order about her unredacted cell phone that Brian Tully released with only messages from Tully to Lindsey and Kate Peter to Lindsey removed. I don't know why Brian Tully released that. That's a big question. I think the answer is because it was right around the time that Karen Reed's first trial was starting in April of 2024, and so Brian Tully and Kate Peter knew Jen McCabe, and they wanted to give the public something to, like the Turtle Riders, something to focus on other than Jen, so they tried to make Lindsey the target of public attention. I'm pretty sure. Through a PI firm run by a guy named Marty Kraft. But then what we're really dealing with is, instead of Judge Doolin issuing a show cause order, we could be looking at an evidentiary hearing on Lindsey's motion, which is really a motion, in my opinion, to ask Judge Doolin to have a contempt proceeding. So Lindsey's not, this is a very strange procedural posture. Lindsey's not trying to prosecute, I don't think here, contempt based on what we just listened to in that motion. First time I really listened to it and understood it, because I didn't have time after it went up on the docket. I think Hoops posted it or something to really read it. And so I just understood, and it's not Lindsey trying to prosecute Aidan for contempt. It's Lindsey saying Judge Doolin hold a hearing and then make a finding of contempt and issue sanctions and refer him for criminal prosecution. So first of all, this is incredibly precarious, in my opinion, for Aidan, because it's out of everyone's hand but Judge Doolin's. You can submit all the motions you want about strike the pleading or whatever that Lindsey submitted, all that stuff. Bradel said he was going to do that. It's not really what matters. If Judge Doolin wants to hold a contempt hearing, it's his prerogative. It's his power. That's just having that kind of hearing is very, very bad, in my opinion. Like, you don't want a show cause hearing for why you should not be held in contempt. You don't want an evidentiary hearing about why you could potentially be in contempt. That's the worst thing possible, because it's not like an evidentiary hearing about whether expert testimony should come in under the Daubert-Lanigan standard, Lanigan, whatever it is, standard, and it's not a evidentiary hearing on a motion that could go your way, technically. It's the worst possible circumstance, because the court is only going to be focused during that hearing on whether you violated its order. Now, Judge Krupp and Judge Doolin are the same court, quote unquote. They both are the Norfolk Superior Court. But you're dealing with an order that Judge Krupp issued in December of 2024 and that Judge Doolin just upheld 3 weeks ago. So you're basically facing the ire of a judge who, if they find factual evidence of it, and this isn't a regular compliance issue either. This is a multiple times reviewed protective order. If they find you violated it through third parties or whatever the fuck, you're at the mercy of that judge. I'm sorry. That's the read of it. You are at the mercy of that judge, and you have a judge who, and a keen eye or ear listening to this would have picked up on it. Judge Doolin, as Tanya Vincent was saying, was not railing on Aidan or the prosecutor by issuing that order. The tone wasn't railing on them. The tone was, you are going to do what I say. And if you're thinking about that, if you're Aidan, or if you're his lawyers, in my opinion, you have to be thinking, oh my God, he's telegraphing that he's pissed at me. If we get to an evidentiary hearing on contempt, anything goes. This Judge Doolin just appointed a new prosecutor, basically, sua sponte from the bench. He never does that. And now he's kind of forecasting, oh yeah, I kind of want to have a hearing on this, this contempt matter. You kidding me? It's incredible. Somebody, I don't know who Judge Doolin is, but somebody say, God bless this man. Somebody pray for this man tonight. Somebody did the right thing. It took forever. I can't believe it. And he did it on his own. He fashioned a remedy on his own. Sua sponte. Yeah, potentially the Attorney General, CC. And the thing is, it's not really the prosecutor's job to argue a contempt motion. It's the judge's job to do it in basically an inquisitional style. You basically, it's not an adversarial process, contempt. It's an inquisitional process initiated by the court. You could, obviously you can motion. I've seen prosecutors, I guess, do it. Lindsey did it here, but more it's the judge's proceeding. You can say, Judge, please do this. But in my lay opinion, it's not a prosecution. It's a contempt proceeding. It's the court engaging in inquisitional findings. It's bad. It's the worst position to be in. I mean, seriously, it's one of the worst kind of hearings you can face. I don't know how this happened. Judge Doolin has really not tipped his hand through many of these proceedings, but we saw, if you were paying attention today to read enough to read The Way the Winds Might Yet Blow, brutal for the defendant, just brutal. Literally telegraphing, I'm making a prosecutor prosecute this, including the Attorney General if needed. You got to understand how big that budget is, folks. Okay, that's oh my God, you don't want to go against, even if it's a special assistant Attorney General. Millions, maybe tens of millions, maybe more. It's one of the most well-funded. It's a constitutional office of the state. It is that would be incredible if that ended up happening. Only for Lindsey's cases, too. Interesting. I think Judge Doolin was sending a little bit of a message there. I wouldn't want to be subject to Judge Krupp's order or Judge Doolin's order, or have to go in for contempt proceedings in front of Judge Doolin after that. My word, folks. What a day. All right, my name's Grant Smith Ellis. So we're heading for another hearing in this matter until November, but basically now we have like a completely new set of facts, circumstances, and chessboard here, which is 30 days. The clock starts ticking. Norfolk County District Attorney's Office got no options. There's no negotiation, ladies and gentlemen. It is you will appoint a new special prosecutor, or you will go to the Attorney General and they will appoint someone, or a special assistant attorney general. You will be prosecuting this case. Now, that's incredible in and of itself. So we need a 30-day window now because nothing's going to happen until the Norfolk DA complies with this order. All right? Then you got this situation where it's not even like the mega motion, quote unquote, that Betterow filed there. And kudos to Betterow. He said on a stream the other day something like, a good reporter, a good journalist sits in the hallway of the courthouse. And, Towell, he always just sits there and the docket gets updated. He just goes into the courthouse. He may as well live in the hallway or something. And I was like, all right, Betterow, thank you for the nice words. But yes, this incredible position here now where we could see the Attorney General potentially, or a special assistant Attorney General if there's some kind of conflict. Just because there's a conflict, that does not save you from being prosecuted by the Attorney General's office. They can just appoint a special assistant Attorney General. It's the same concept. It's more the idea that Judge Doolin was saying, potentially, if this plays out, like if you can't find anyone, Norfolk DA, okay, fine, that's cool. You don't really have a big budget anyway. You just tell the Attorney General I ordered them onto this case because you couldn't find someone. Mind blown. Mind blown. Then, as I mentioned, instead of like the motion to dismiss, this renewed motion to dismiss, which was actually 3 motions in one, I think it was like, I forget what the other 2 parts of it were. It was a little bit of a weird, to remove Mello from another 2 cases, and then one other motion, I forget what it was. That wasn't even the topic of discussion. I didn't even know what to make of the hearing because they didn't even get to it. They were like, oh, we're going to have to put that off. And then as if Aidan could have just gotten that one thing like, oh yeah, we'll get to that like some date maybe at the same. No, because the hearing ended with Judge Doolin getting up there and saying, on the motion for sanctions, which was the last thing that Cosgrove brought up. Well, we got to think about a hearing for that, maybe sometime in November. Mr. Betterow, Mr. Bradle, if you want to file some pleadings there about that, that's all right. But, I'm pretty comfortable with my order. That's exactly how he said it. And I feel pretty comfortable with my order. And that's incredible. So you have so the 2 big takeaways from today's hearing that only lasted like 20 minutes. One, the judge ordered the Norfolk DA to appoint either the Attorney General, a special assistant Attorney General, or a special prosecutor to continue the Lindsey Gaetani cases. So that a whole office, whatever the hell gets appointed, basically you're answering to Judge Doolin. I mean, yes, you're technically going to be under the purview of either the Attorney General's office or the special prosecutor, but like you end up in that courtroom, don't expect to get off that case like in the next like 3 years. Are you fucking kidding me? Sorry, are you kidding me? He's going to order you on that case, and I really hope a special assistant Attorney General shows up and he's like, all right, I'm ordering you to be on this case now. That would be incredible. That would be absolutely incredible. You saw the Norfolk DA's emails about the budget constraints with the Reed trial. Imagine if it's almost like either the Virgin Mother or God or somebody's watching out for Lindsey, because we could see a situation now where they attempted to screw her every single side of this thing, and she ends up like with the Attorney General's office as just her prosecutor in the context of these cases, right? But only prosecuting her part of the cases. What? I swear it's like divine intervention. You could have asked me, as I mentioned earlier, to draw every possible result of this hearing. That was not on the board. Not to mention an oral order reinforced from the bench. Oh my God. And then to couple that with the fact that the Judge Doolin is, by doing that, and then saying, yeah, I'll think about a hearing on this contempt motion. And then he said to Bradle, did you read it? As if Judge had read it. Obviously, he called her Miss Gaetani. Folks. Oh my God. Like, I don't know what to say right now. This is incredible. I didn't think I didn't think judges in Massachusetts, I mean, I respect Judge Doolin, of course. He's never done anything that I thought was untoward. Very good jurist, very deliberative, as I mentioned earlier, like very, very erudite. Spends his time on every single ruling. And the reason I know is I have to wait. I have to look at the docket. He puts a ruling up. I have to go down there. It's like 40 miles. And then I have to like get the document. I have to take pictures. I have to upload it for you all. I have to drive home. So like I've seen his deliberative process in the sense I've seen how long it takes. And you have to refresh that docket all the time. Like all the time. And he's a very, very refined, like he really contemplates his rulings. And so that's what kind of tipped me off in real time. I was like, wait a minute, is he ruling from the bench right now? And then I was like, wait a minute, he's ruling from the bench and ordering them to appoint a new prosecutor and potentially the attorney general. Oh my word. What is this? This wasn't on my bingo card. Oh my word. I don't even think I realized the weight of it until like 10 minutes later. I mean, I was trying to clip it and upload it, and I don't think even I understood the full weight of it. Even now, I'm just like, oh my God, I can't believe he did that, Judge Doolin. In a good way. I'm just like, oh my God, there is hope. And then to follow it up with, oh yeah, I'm thinking about a hearing on the contempt. Oh my God, you're telegraphing you're going to have a contempt hearing after the Attorney General is potentially on the case. Oh, wow. Yeah, Chris. So what's really interesting now is that the other witnesses are left in this position where they have this kind of not really well-funded, like kind of spastic prosecution, like the special prosecutors on the Kearney cases. Those are, of course, the October 2023 charges out of Stoughton District Court. There's 10 of them left that got bound over by a grand jury on December 20th of 2023 against Kearney for intimidation of the witnesses in the Reed trial, Julie Nagel, Brian Albert, Chris Albert, Colin Albert might be in there too. Some other people I don't remember right now. And then, see how you send a message without being rude? And then those were bound over in December of 2023. There's 10 indictments left from that. Most are felonies. Then you got the December 23rd, 2023 criminal charges against Aidan that were charged in Stoughton District Court in December of 2023. I think around Dedham District Court. 23rd or 26th or so, and that was for illegally, allegedly recording Lindsey Gaetani, and then submitting an edited version of the recording into court for some reason. I don't know why Aidan did that, especially apparently when there's an original version of the recording pursuant to some of the statements in court. And then also for intimidating Lindsey for allegedly going over there on December 23rd, 2023 against Karen Reed's advice, and against his lawyer's advice, apparently, according to a leaked group chat message from Facebook in May of 2024, going over to Lindsey's apartment, and then, according to the affidavit from the search warrant for Karen Reed's cell phone, allegedly telling Lindsey that she shouldn't cooperate with the grand jury. She could remove information from her phone or something, that Aidan would get her a lawyer, but only if she agreed to meet with the lawyer, only with him present, because she had, quote, broken his trust. Just like wild stuff. And that new grand jury, by the way, was apparently, it did go forward. And then in time, it came out that that was about Karen and Aidan, and witness intimidation and conspiracy, because Aidan Kearney, between October and November, really August and November of 2023, had started telling Lindsey Gaetani about his communications with Karen Reed that included in writing Exhibit O to Karen Reed's search warrant affidavit, which says that Karen Reed told Aidan Kearney that in November of 2023, November 28th, 2023 to be specific, that Karen Reed told Aidan Kearney that Karen Reed and her team had ex parte conversations with former U.S. Attorney Josh Levy, which was right in the window of time that Jessica Leslie, the grand juror leaker, was leaking information. She started leaking in August of 2022, which is the same month that Alan Jackson joined Karen Reed's legal team. And Josh Levy, who was one of the U.S. attorneys in charge of that grand jury, Leslie was leaking about 4 different cases, probably the Birchmore case, definitely the Reed and O'Keefe case, definitely the CDL case, one more case we can't really, the load of us journalists involved in this can't really figure out, but there's one other one in there. So right in the middle of that, November of 2023, Josh Levy's leaking ex parte grand jury information to Karen Reed, which she's telling Aidan Kearney about, he's putting in a writing. I think he was trying to just show off for Lindsey, but you don't, like, come on, like, what is it, first day in the intelligence community, bro? I'm not in the intelligence community, I'm not part of the government, I'm a towel. But anyway, so he's bragging to her, and I don't think that was a very good idea. I mean, she's brilliant and stuff, but, like, why would you ever say that to her? Don't say that stuff. But anyway, like, why would you say, even if it's your significant other, unless they are read in on the intel that you are sharing, why would you ever share that with someone? It exposes them to an incredible liability, which shows you don't love them. 2, it exposes your own credibility to an incredible risk of liability. You will never be trusted by the intelligence community. Again, pillow talk and honeypots are how they get operatives. If you are chasing women, or if you're a woman chasing a man, or if you're either or chasing the same gender, I don't really care. If you chase sex, they will compromise you. How can you not understand that? So if you get compromised by someone who's not an agent, just someone who's your partner, and you're just telling them stuff about protected federal investigations, what do you think your reputation is going to be like among the intelligence community when you're doing that and they haven't even honeypotted you? You just voluntarily started putting this shit in writing. They're going to look at you like you are out of your mind. So anyway, Karen Reed apparently is telling Aidan Kearney that she's having ex parte conversations with Josh Levy. Now, the grand jury that Leslie was leaking from was impaneled in May of 2022 when Rachel Rollins used to be U.S. Attorney in Boston. Now, think about this. In 2020, Rachel Rollins and Aidan Kearney, Rachel Rollins, a hyper-liberal known for her soft on crime stance, who also hated Michael Morrissey, worked with Turtle Boy to send a Republican operative named Rayla Campbell to Joe Kennedy Jr. events in the Senate race against Ed Markey so that Ed Markey could win the Senate seat. Now, interestingly enough, Rachel Rollins then got appointed to the position of U.S. Attorney right after that. And you might say, well, Grant, that's a stretch. No, because then within a few months, Rachel Rollins, part of the reason she gets thrown out of office by the DOJ OIG is because she attends an event in Andover with, guess who? Dr. Jill Biden, the wife of the then president who appointed her. Now, what does that mean? Well, if you really think about the geopolitical implications of the 2020 Senate race between Ed Markey in Massachusetts and Joe Kennedy Jr., well, one of the things you're going to realize is that, think about 2020. The leadership around Biden did not know that the chaos of 2024 was going to happen with Kamala and Biden not really being up to it. They're thinking ahead to 2024. Why? Who's your biggest target if you are a sitting Democrat and you're worried about a primary challenge 4 years from now? Well, what if JFK's, nephew or whatever it is in the House of Representatives? And what if JFK started his career in the House of Representatives? And what if that new young Kennedy with red hair and a sort of photogenic face, what if he is running for JFK's old Senate seat? What if he's on the same exact trajectory as JFK? Oh, we can't have that. We, as the Biden White House, cannot have Joe Kennedy Jr. beating Ed Markey for Senate. And how it got to the point that somebody talked to Rachel Rollins and she came up with the brilliant idea to reach out to Turtle Boy so that Turtle Boy would talk to Rayla Campbell to send her to Joe Kennedy Jr. events to help Markey. I don't know, but that's why I think Rachel Rollins became U.S. Attorney, someone who, in my opinion, was uniquely unqualified and fundamentally ethically unpredisposed to being able to run that office, who then in turn immediately tried to interfere in the 2022 Suffolk DA primary between Kevin Hayden and Ricardo Arroyo because Rollins wanted to see her progressive vision continue through Arroyo. So she worked with Daniel Medved, the same professor who's involved with advocating in the media on behalf of Karen Reed's team. She worked with Daniel Medved to get a story leaked about how a non-existent federal probe into Kevin Hayden to increase Ricardo Arroyo's chances in the Suffolk DA primary. Sound familiar? Oh, hell yeah. And then when she got caught, as she was being forced out between November of 2022 and May of 2023, by the way, During a December 2023 interview with the DOJ OIG, Rawlins perjured herself, got referred for criminal charges, and the Biden White House in January of 2023 shut it down. Read the DOJ OIG report from May of 2023. It's 162 pages. If you don't believe me, it's in there, black and white. So anyway, between November of 2022 and May of 2023, you got this weird situation where Rawlins knows she's getting forced out. Levy's going to take over the office. The people who take Rawlins out are Josh Levy, Bill Abley, still head of the criminal division, Dustin Chow, I think still head of the public integrity unit, and the then executive officer who was also the press secretary or the communications director of the office. Those four people, without being named, they're named by title, were the people who cooperated with the DOJ to take Rawlins out, DOJ OIG to take Rawlins out. Now, why is that interesting? Well, one, because it shows that people in that office knew that Rachel Rawlins had a proclivity for weaponizing leaks about non-existent federal probes to interfere in particular, district attorney races and matters. Second, Rachel Rawlins and Michael Morrissey had a bifurcated history of tension. One, Rachel Rawlins had this list of 25 crimes she wouldn't prosecute, and other DAs critiqued her, not just Michael Morrissey, but others. Rawlins, I'm pretty sure, was the one who first called Morrissey a meatball, in fact, because of his criticism of Rawlins over that issue. Then, Rawlins, in 2019, I think, was one of the first DAs in the state to advocate in a formal motion to a court that a youthful murder defendant under 25 should not face a full life term because they're not fully developmentally ready to be able to serve that sentence based on when they committed the crime. Now, to Rawlins' credit, in 2024, the SJC vindicated Rawlins' perspective. That is now the law. But in 2019, that was an extreme and radical position. Michael Morrissey called her out for it. She went to war with him again. Read the Boston.com article about it. Rachel Rawlins, I think, has a proclivity, in my opinion, to hold a bit of a grudge. When she became U.S. attorney and she realized she was on the way out, well, maybe the Sandra Birchmore probe started back in May of 2022 because former chief of the Canton Police, Ken Berkowitz, went to the FBI and told them that the FBI covered up, the MSP unit detailed to the Norfolk DA covered up Sandra Birchmore's murder, potentially because Yuri Buchanan and John Fanning used to work in Stoughton with Matt Farwell and Robert Devine and Billy Farwell. I think they all worked there. And furthermore, that Brian Tully, the unit commander, was partners with John Fanning for 20 years. All right. And in that regard, it is very interesting, I think, that Chief Berkowitz, who may have been very offended that his unit, so Sandra Birchmore was murdered on February 1st, 2021 at 9:23 p.m. in her apartment in Canton. Okay. On February 4th, Monday in the morning, the Canton police do a wellness check after they get a call from Sandra's colleagues at the school where she worked as an administrative assistant. Now, the Canton police respond on Monday, February 4th. By Wednesday, February 6th, the Canton police have collected the following evidence in order. And if you don't believe me, you can read pages, I think, 97 through 101 of the Canton Police Department audit report released in April of 2025. Point by point. Number one, the Canton police confirm via a witness who was the maintenance worker at Sandra's apartment building that Matt Farwell was the man on camera outside Sandra's apartment in the elevator at 9:23 p.m. on February 1st, which is exactly when Sandra died. Two, that the man was Matt Farwell, and he was the same man who helped Sandra move into her apartment. Three, that when the Canton PD went to Sandra's school, they got information that Farwell was telling people that Sandra was pregnant with his child, that he had abused her since she was a child, and that he was going to, quote, take care of the problem herself if Sandra decided to carry the baby to term. All right. All of that information by February 6th of 2021 was passed over to the MSP. John Fanning and Dwayne and Garino and this whole unit, I think, really, then facilitate a report sometime over the next 6 to 12 months that exonerates Farwell and says Sandra dies from self-harm. Well, I think that's why Ken Berkowitz blew the whistle before he died of cancer, and that's why there was a grand jury impaneled in May of 2022, and it was really about the cover-up of Sandra Birchmore's murder. Well, one, it was about Sandra Birchmore's murder. And by the way, did you know that Matthew Farwell is charged with murder of a cooperating federal witness? Have you ever looked at the statute for murder of a cooperating federal witness? Have you ever looked at who you have to talk to in order to qualify for a charge under who the victim has to speak to qualify under that statute? Let me give you a hint. There's no clause in that statute that allows you to speak to a state official. That means that Sandra Birchmore was speaking to someone in the federal government about something before she got murdered, or she was attempting to do so. Now, what makes it so, why does that make everything so interesting? Because I think that the investigation wasn't just about who killed Sandra and why, but how was it ruled the result of self-harm instead of the very obvious murder that it was. Well, that starts 2022. I think May of 2022, the grand jury, Jessica Leslie was on, the grand juror leaker who's going to be sentenced on October 4th. I think Jessica Leslie, ladies and gentlemen, in August of 2022, somehow leaked to Karen Reed or Alan Jackson that the Norfolk DA was dirty because they covered up, and that MSP unit because they covered up Sandra Birchmore's murder. All right, so therefore, Alan Jackson, that's the skeleton in the closet. It wasn't what the people in the House were doing. I'm still a little suspect of who they know, but I don't think that's the big deal. I don't think Jen McCabe's social life is the big deal. Nobody cares. Nobody fucking cares. Sorry for cussing. The big issue is that Jen was friends with Tully. Tully's unit knew literally where the bodies were buried, and I think they brought on the PI, Marty Kraft, and Kate Peter to insulate their exposure from the coming publicity that they knew was going to be brought upon them by Alan Jackson. Therefore, I think what Alan Jackson's actual plan was, I don't think he ever said this, but this is what I think he was up to. I think Alan Jackson was using the fact that this unit had to sense that the more attention got paid to them, the more the microscope of national and international sort of focus zeroed in on Norfolk County, Massachusetts, the more likely it was that Sandra Birchmore's grave was going to become the locus of the investigatory scrutiny. And that is why I believe they had something to hide. Tully had something to hide. Banning had something to hide. Uri had something to hide. Garino had something to hide, although I'm pretty sure they made him do it. They had something to hide, in my opinion. And so they were worried. And who would you bring in? If you had covered up a murder, if you were a state police unit, you'd bring in someone like Kate Peter. Because you can read her in on that. She's hardened. She doesn't give a fuck. She lost 2 of her kids, and I don't think she even fucking cared. So who the fuck's the perfect person to be like, bruh, if that shit gets national attention, we're fucked. So you better control that fucking narrative and handle all these like different people that get too close to this, or we're going to get our spot blown up here, not literally, figuratively. We're going to be exposed for what we did with Birchmore. That's what really pisses me off. Like that it's so hardened. It's such a jaded fucking view of the world. It's like people who leverage children to stay in other people's lives. Okay? They're the sickest, most demented humans, especially if, like, they're only not in jail because, like, they gave people up or stuff like that for serious drug crimes, and then they walk around like sanctimonious hypocrites. That's the only type of person in the world that I loathe more than someone who would knowingly try to manipulate a public narrative to insulate a state police unit from accountability for covering up Sandra Birchmore's murder. It's the lowest, most disgusting, most base form of existence. It requires one to have literally numbed their soul to the point where you can sleep at night having participated in that. I don't think there's enough alcohol, drugs, or sedatives in the world that could make me sleep if I was a party to such a thing. And I question how some of these people do it. But let me bring it back to the point here, which is 2022. The feds clearly, I believe, we're starting to poke around. And come 2023, I think Brian Tully's unit was desperate. Who was going to find out because of the coverage of the Reed case? Could they make sure that Kate Peter got close enough to Netflix and Gretchen so that they couldn't find out what was actually going on? And could the Birchmore cover-up be kept alive, even in light of the national spotlight? When you think about it from that perspective, when you think about the fact that some people may not have been loyal to the Justice for John O'Keefe movement, but were instead primarily loyal to Brian Tully's unit. And when you think about the fact that maybe Tully's unit didn't run the best investigation of Karen Reed, maybe there were some flaws, but if you think about the fact that they did get her, but if you think about it in the context of Karen knew from the jump that the MSP were dirty over Birchmore, then you understand that's why it was going to become an incident. Everyone knew, everyone around Tully, his friends, all of them, the unit, they knew they covered up Birchmore's murder. And they knew Karen had it in her hands, if she could just figure out the PR, and that's exactly what she did, to put enough pressure on them. They took her to trial anyway, and it destroyed the fucking Norfolk DA. It destroyed Brian Tully's unit. It cost them dearly, and she's a tactical fucking genius. I'm fully of the opinion that Karen Reed staged a fake falling out with Natalie so that Natalie would get in the orbit of MSP in June, July, and August of 2023 and feed information back to Karen. Likewise, I think Brian Tully thought he was slicker than he was by using the criminal prosecution of Aidan Kearney, not to get a genuinely, in my opinion, bad guy who was deserving of the indictments handed up by a grand jury of his peers, but because Tully wanted to know what the real target of the federal probe is. If you don't know what a backhand is, folks, a backhand is where you investigate one thing on the surface because you're dealing with a very high-level operation like the state police, or a paramilitary intelligence gathering operation, so you trick them. You make them think they're under investigation for John's death and the investigation of that death, but really you're investigating them for the cover-up of Sandra Birchmore's murder. And that's exactly what I think happened to this unit. That's what I think Brian Tully was trying to figure out from August of 2023 until about December. I think they eventually put it together, and by August of 2024, Matthew Farwell got indicted. Now, it's a question of this. As a result of today, I want to be very clear. This is what was called for. There needed to be an independent voice with power and who takes no nonsense, who came into this and said, nope, it's out of your hands. And that's what Judge Doolin did today. The exposure potential. Someone just needed to not either be involved with Karen Reed or Aidan Kearney or the Norfolk DA or Kate Peter or Marty Kraft and prosecute this. Now, all those other witnesses, I have no idea what the hell is going to happen there. But at least for Lindsey, Judge Doolin was like, enough of this nonsense. And that's why today was such a big deal in light of that historical context, because just tracing that very insidious pattern of events over the past 18 months, you can see this became a proxy war. It was Michael Morrissey on one side with his lieutenants, Brian Tully, not literally lieutenants, his marching soldiers, Brian Tully, Kate Peter, Marty Kraft. And then it was Karen Reed and the DOJ on the other side, okay? And their soldiers were like the Free Karen Reed movement and Turtle Boy and Natalie and all these other people. This was an intelligence community proxy war, and that's why I've been trying to tell people for so long Lindsey Gaetani was not involved. She was an unwitting pawn. These two factions both took advantage of her, including Brian Tully, who was more interested in preserving his unit's reputation than actually defending the interest of the vulnerable, in my opinion. I think Brian Tully's a terrible person. Does that mean that he's a bad person for trying to hold Karen Reed accountable for John O'Keefe's death? No, of course not. He's a bad person because in what fucking world do you, as a fucking state police officer, who you are entrusted not just to get the bad guys but to protect the most fucking vulnerable? One, how do you justify what happened with Sandra Birchmore? Two, how the fuck do you get it in your fucking mind that you're gonna take a 15-year unredacted extraction of a fucking vulnerable victim's cell phone and release it to a fucking defendant known for promulgating exactly that material? What fucking headspace, what satanic fucking chamber do you and Kate Peter have to be drinking blood from fucking cups in to think that that's fucking okay? Fuck you! How do you even get in the headspace where something like that becomes acceptable? They'll rot in that unit, whether enabled by Morrissey or whether he didn't know about it, I don't fucking know. But the point is, the rot in that unit was so deep that they lost their fucking souls. They didn't think of victims as victims. They re-victimized victims. Because it was a political fucking war, and these people are so hardened, I guess, that they don't understand what it means to be vulnerable. And these were police officers, detectives, people entrusted to uphold and protect the dignity of the most vulnerable, and they fucking used victims to advance a political agenda to deal with the fact that they covered up a fucking murder. I'm done being gentle about this. Fuck these people. And I'm not saying that it was wrong for them to investigate Karen Read. I am pleased someone tried to prosecute her. I'm pissed at them because they were thinking about it from the perspective of their own liability for an unrelated case, and they fucked everything up. And introducing Kate Peter to this shit. Oh my God. It's a disgrace. It's a disgrace to the people who were hurt. It's a disgrace to the vulnerable. I frankly do not understand how Jen McCabe, Brian Tully, and Kate Peter go to bed each night. I don't get it. I don't know. Maybe there's something that shuts off the GABA-1 receptor or something and just makes you go to bed. I don't know. Never heard of such a thing. But I'm just saying, I don't know how you do it. How do you do it? But anyway, Judge Doolin, without giving a extemporaneous, bloviating, cuss-based rant like I just did, instead, in my opinion, was like, fuck all of you. You're not being involved in this prosecution anymore. Someone's going to protect this fucking woman, Lindsey Gaetani. I'm making you appoint someone. I love that man. Good for Judge Doolin. But still, we never should have gotten to this point. This is incredible. With the Massachusetts State Police, the fact that they had a unit operating like this for so long, this is worse than what John Conley and Whitey Bulger did. This is institutional rot that is so pervasive that it requires fundamental reform of the Massachusetts State Police. They're not incapable of solving crimes. I'm sure most of the Massachusetts State Police are wonderful. Sometimes I have great interactions with them. One time, Sergeant Hartman, though, did grab me and kind of like push me, but otherwise he's very nice to me. We have very congenial interactions. Some of the other troopers are like, Grant, tell us about statutes. And I just quote random statutes. One time I was like, Trooper, did you know 94G 13C has an exemption where medical patients, it doesn't apply to medical patients? And I saw him kind of thinking, he was like, all right, noted, doesn't apply to medical patients. That's a statute about smoking in public. Anyway, my point is, I don't think the state police officers that I generally run into are troopers are bad people. I think most of them are wonderful. They've never been really mean to me. They do good work. They're out there protecting our roads. They stop people from speeding. What else do? They go after commercial truck violations. They investigate homicides. Like, on the whole, and this is why I think we have to be careful about how we talk about this. I am not saying that the entire Massachusetts State Police is just rotten. I'm saying that when you have factions or sections within the institution that understand its machinations and are able to thus manipulate the bureaucratic structure and avoid accountability, you lose the confidence of everyone. And how do you think some of those good troopers feel when they have to go out there? Yes, people like me are going to smile at them and bless them and whatever, because I know they're not part of the problem. But most people look at them and they think that they're fucking hated. They don't deserve that. They literally put their lives on the line for us every day. And if we're going to give them the respect they deserve, if we're going to make the profession have the respect that it deserves, then this kind of institutional rot can't be looked at as just an embarrassment, and it can't be looked at as something that, oh, we just wish didn't happen, maybe some guys are going to go away. No, you point at it, you scream it from the rooftops, and you say, if this happens even once, then we have so failed as an institution, we must fundamentally reform from the ground up. And this wasn't just once. It was Birchmore, it was the phone extraction, it was the SA report leak, over and over and over and over again. They knew the law. They were an old boys club. They abused it. They had cover, and it was systemically enabled. And that's why I think to save the profession of policing in Massachusetts, there needs to be a full-on, unbridled discussion about how this happened, how the personalities involved were able to do what they did, and we can't be so tribalistic that because someone we support as to their views on one case, right? We cannot be so tribalistic that we just block out everything bad that they do, or this rot will continue. And it is pernicious, it is insidious, it is invidious. It undermines the faith that citizens completely removed from this situation have in our system of government. It undermines victims' confidence in the ability to seek redress in the face of serious fucking harm because they think the system doesn't actually care about them. It's just using them to get someone bigger. We cannot allow this to perpetuate, and the only way to fix it is to hold up situations like what happened to Sandra Birchmore, and what happened to Lindsey Gaetani, hold them up in the national spotlight and say, we, the Massachusetts State Police, have failed you. Brian Tolley failed these people. John Fanning failed these people. Nick Garino failed these people. Yuri Buchanan failed these people. We need to say that. We need to highlight it. We need to say, this happened even once, therefore we are not good enough. Not only are we not good enough, the very fact that either of these things were able to happen, the Birchmore cover-up, the phone extraction leak, is such a pervasive, systemic degradation of the faith that victims and the public have in the justice system that our only option is to talk about this. Congressional hearings. We need the State House to have congressional hearings. We need these people to answer for what they did, and we need to make sure it never happens again. And the only way you do that is by finding out what aspects of the bureaucratic structure allowed this to happen. And it's not going to be comfortable. I don't think it's going to be comfortable for anyone to talk about the fallout of any of this. But that's exactly what happened at the CCC on a smaller scale. And if this country matters, if this form of government matters, if this republic matters, then we will fix this. We will fix it together. We will address the hard questions. We will address the uncomfortable questions. We will shed our prejudices and polemical biases at the door. We will engage in no fear, no favoritism, and we will look only for the truth and nothing but it. And if you are incapable of doing that, you're contributing either consciously or subconsciously to the problem. It's our only option. And you can't just say, because they prosecuted Karen Reed, we can't talk about anything bad that they did. That's tribalism. That's polemical. That's what drove us to this point. So, all right. Thank you very much for... Troy's like, I'm good with the troopers pulling over the commercial drivers. All right, Troy. Well, there you go. You found a reason to say something nice about the state police. All right, so that's where we're at. That was more than a recap. That was a pontification. I was yelling. All right, a few things. One, I'm hungry, so I'm going to go get dinner. Two, we'll be back together soon. I'll have more to say. That was quite a big day. We're in a 30-day holding period now. I'm going to collapse after yelling that much. I've already been having some issues. We're in a holding period on the Kearney case. New prosecutor incoming, maybe the Attorney General's office for just Lindsey's cases, and then a contempt hearing potentially in November. That's where we're at. If you like this stream, if you benefited from today, no sponsors, no ads other than what YouTube provides. We love Tell YouTube. Thank you very much for YouTube support. If you want to send a donation, I'm going to drop my links in the chat. Listen, this is a public information service. It's unlike other channels. Your donations go towards feeding me, offsetting server expenses, facilitating my gas. Like sometimes I need medicine, all this different stuff. I actually have doctors and school. So anything you contribute goes to a good cause. But really, it's not about me. What I'm trying to do here is create a public information service designed to educate, inform, and entertain the public, such as to ward off the usurpation of our representative forms of government worldwide. My name is Grant Smith Ellis, and if you have benefited from this service today, it's really not a donation for myself that I'm looking for, although anything you want to send is very helpful. God bless you. Please don't donate. If it would be a burden, please don't donate. If it would take away from other causes that are important. I would not like that. But there's a Venmo, which is at Grant-E1. Someone asked, there's a Cash App, which is the money symbol, Grant Smith Ellis. And then there's a PayPal, which I don't even know, paypal.com/PayPal.me/Grant, whatever it is. Oh, thank you so much, Anthony. I really just want to extend an appreciation as well to all of you in chat. Let me do a little scrolling. Thanks, Troy. Appreciate you. And yeah, if you like these rants, you want to see them, keep going. There you go. Donation links all around. Support good content. We only exist because of you. You can buy me a coffee, whatever it is. But like, we keep going. Someone like me only does this because regardless of your views, like there are people willing to support me. There's no one who's just going to fund ruthless, unequivocally sort of destined to pursue truth based journalism. There's not a market for it. I'm sorry, we have a lot of markets for different commercial apparati in the United States. There's no one who's going to fund some guy who thinks he's a towel and has 100 million views on social media and wants you to empower yourself to ward off the usurpation of the government. I'm sorry, no one wants to fund that. You are the only one who's going to do it. But yes, I want to say Troy, Anthony, Barton, Emily, Suzanne, it was great to see you. Emily Shem, thank you for stopping in. By the way, Troy is one of the folks who has a different point of view on some of these cases. As long as Troy does not engage in trolling or anything like that, Troy can stay around. Noel, yes, I do need to watch my blood pressure, which is why I'm going to go get a sandwich. Tanya Vincent, it was great to see you, my friend. God bless you. I love the fire emojis. Francesca Towel, it was great to see you. Thank you so much for tuning in. Respect, thank you for coming in earlier. Elevate the process. I agree, Judge Doolin has done his homework. Yeah, that'll be argued by a newly appointed prosecutor. CC, thanks very much for tuning in. Love the American flag in your profile picture. I think we can make you a standard super towel because of that. Who else? Chris, it was great to see you. Carolyn Phillips, you're so appreciated, my friend. God bless you. Thank you for stopping in. Christina, Dave Harris, it was great to see you. LS, my friend from across the pond, you are a super towel. Larry P., yes, the mega motion did finally go up. The reason why it didn't go up was because Judge Doolin had to rule on a motion to impound the unredacted copy, which he did do on the 22nd, according to the docket. Butterflies are free. Yes, I don't really want to watch Bettero or Turtle Boy, but thank you. Napa Valley German Shepherd Rescue, I love your username. Thank you so much for tuning in, my friend. Oh, look at all the towel friends. Ruth Lang was here. I think she went to bed. It was getting dark. Justice for Johnny. God bless you. Jesse Roberts, it was so good to see you. Dark Side of the Moon, I'm so happy we got to spend some time together. Bunny Towel was here. Bunny, I have Pete Bunny Towel. Pete Bunny Towel, hold on. We haven't been able to play trivia in a while, but this is Pete Bunny Towel, and he just wants to say hi to Bunny Towel. He also wants to let you all know that he was right and the communists are a threat to America. All right, Pete Bunny Towel, you extolled the virtues of anti-communism and then the commies started to rise up. How are you feeling? You're resolute. You are a bunny. You are part Peep and you're going to take down the damn commies. All right. And you love America. Do you like my new broadcasting announcer voice? I feel like, I could be in the zone more often. No, thank you for the endorsement, Pete Bunny Towel. You want to go back to napping? All right, well, you got to say hi to Bunny Towel. She's very happy to see you. She really loves you. You're adored by millions all around the world, Pete Bunny Towel. They love you. He wants to know if that means he should run for office. I think so. His platform is down with the commies, vote for Rue for mayor of Boston. Not Mayor Wu, vote for Rue. All right, Pete Bunny Towel, see you very soon. He's sleeping now. Butterflies are free. It was great to see you. Who else do we got in here? Maui Swift was here. Thank you for popping in, my friend. It was great to see you. Thanks very much for the comment. Oh, we had a lot of towel friends. Anthony Barton, I already got to say hello to you, my friend. You popped up again. Well, Jack D65 was here earlier. Oh, yes, I got to say hi to him. He is Super Towel. Elaine Gibson, I'm sorry for the delay in getting the audio up. I had to connect to the court audio. Got a secret, you can keep it. Thank you so much for joining as well. If you're new to this stream, I like to go through all the comments that I can and say hi and thank you to people. Christine, thank you for stopping in. Dewdrops did actually pop in about a month ago in the morning and said hello, and then I think Dewdrops also said hello on Bossy Texas Chicks channel one day, and we extend our love to her as well. Yes, Ruth is here. RP, my friend, it's so good to see you. Hello, you are a super towel. I put a heart in the chat for you. All right, so I'm heading to bed. We will do another stream soon, not promising anything. I'm in school now. As you know, Tal's got a few more months till I graduate. I told my dad before he passed away that I would make sure I do that, and that is going to happen. So thanks again for watching with me. I'm a tired little towel. I don't even have a vehicle right now. I need to get a new battery for it. So, oh, maybe that's done now because I called AAA. Anyway, all right, towel friends, I got things to do, and you know how I like to end every stream. If you really benefited today, if you learned something, if you became a more empowered, informed individual, then there's one way, there's a bunch of ways you can pay it forward, but you know what I'm going to say. You can look for reasons to pay it forward and do things like donate to homeless veterans, ladies and gentlemen. There's not a single veteran in the United States who should be homeless against their will. We failed as a country. If that's the case, you can donate to help make sure that's not going on today. You could donate to animal shelters. Those are wonderful, especially if they're run by veterans. Maybe a animal shelter not run by veterans if you can't find one. People like animals and veterans. But it can be something as simple as smiling at someone on the street, saying hello to a friend or neighbor, or reaching out to a family member you haven't heard from in a while. Maybe you even donate 200 tomato plants like Francis Futrell did one time and have them designated honorary towels forevermore. Yes, in that way, ladies and gentlemen, I believe we can change the current realpolitik from one centered on preserving, expanding, and demonstrating our power to instead one centered on expanding, preserving, and demonstrating our capacity to engage in unconditional love. In that way, we'll be able to live up to our tau eudaimonia or summum bonum in the ancient Greek or the Latin, respectively, our greatest good. And in that way, those small acts of service and compassion will ripple outwards and bring about a new digital epoch defined by Aquarius the water bearer standing tall and carrying a towel. Still got it, towel friends. Love you very much. Appreciate all of you. Thank you for your support. Thank you for watching Towel Channel. Towel friends on the X, I'm going to let you go a minute or two early. God bless. Enjoy the rest of your Tuesday or Wednesday, whatever it is. I'm a little tired, towel. We'll see each other again soon. And thank you for watching. Grant Smith Ellis here. I appreciate it.